Hi everybody. Today I would like to speak about the Uberization of the world, specifically about the labor and employment law issues here in Europe with gig workers and platform workers. As you probably know, there are three legal issues concerning gig work. We're talking about fictitious self-employment, in addition to some competition law and tax law issues. We have the problem of union representation of gig workers, and we discussed the question whether they should be included into the national social security systems. One should know that the EU has no competency for social security issues. This is a matter of the member states. If we look around at relevant court decisions, we come across, first of all, at the ECJ decision regarding Uber 4 years ago that did not classify specifically Uber drivers, but said that the Uber drivers and the whole Uber business belong to the transport service. The main reasons was that the drivers are not free in designing their activity. They underlie a tight quality control of Uber, and there is a tight evaluation and rating and feedback system for the Uber driver. 2 years later, the court decided on Yodel and took a different approach. It said that self-employment would be possible under certain criteria for the national lawmakers. So if certain criteria are met, then these delivery drivers would not be an employee. The first criterion was, can they use subcontractor in order to provide the service? Second, can they accept and not accept the work at any given time? And third, may they determine the maximum orders? And fourth, can they work for direct competitors of the presumed employer? And last but not least, can they or can they not determine their working time within a certain parameter, and so that they can determine the working time according to their personal preference and not to the interest of the potential employer. Even if Yodel has specified certain time slots in which the person concerned had to provide his service, these did not prevent him from being classified as a self-employed person, so says the ECJ, since in the meal delivery business, prompt delivery, especially at peak meal times, is essential. We have also seen some other international decisions. If we look at Spain, the Supreme Court there decided last year regarding the Glovo food delivery couriers that they are employees. Because Glovo is not just a mere intermediary between restaurants and the delivery people, but the main focal point, the main actor that decides on costs and conditions of the service. Furthermore, Glovo employs delivery people to perform their duties, where to, at what time, within the scope of the employer's professional organization. The Amsterdam Law Bank decided the same thing for delivery drivers, namely that they are employees. The claimant, interestingly, was a union from the transport industry. And as a result, the collective agreements of the transport sector applied, and delivery had to pay pension contributions into the pension fund for the Dutch transport sector for the drivers. In the Netherlands, the following criteria must be met for an employment contract to come into existence. First, the employer can give instructions to the employee. Second, the employee is obliged to personally perform the agreed work during a specified period. And thirdly, the employee receives remuneration. The court argued that the delivery of food was the core activity of the company, so that the name Deliveroo already indicates what the business is all about. And delivery organizes the customer's ordering process, provides the digital environment for the drivers, and advertises the unified service. The company does not just play a pure intermediary role. The same happened to Uber drivers at the Amsterdam Court of Appeal last year. Uber drivers are being seen as employees, and the service fall under the collective agreement for cab traffic. The judgment speaks of a modern employment-employee relationship. Interestingly, the ruling was initiated by another union. The court also listed the 3 characteristics that the drivers met: personal performance of work against payment of a fee in a relationship of authority. The French Cour de Cassation de Paris came to the same conclusion last year with regard to Uber drivers. They are being seen as employees as well because the drivers do not have their own clientele, but rather the clientele of Uber. The drivers are not free to decide on their fare and the overall conditions of carriage, and they are a part of a transportation service organized by Uber. And finally, there is a relationship of subordination between Uber and the drivers, since Uber can give instructions, supervise the execution of the trip, and impose sanctions in the event of non-compliance with the conditions. The UK Supreme Court in 2021 came to the same conclusion. Uber drivers are employees, as also the indirect control of employees via a rating system is decisive. This can have a relevance for the employee's position. In this case, a poor rating resulted in a sanction, which could range from a warning to a termination of the contractual relationship. If we look at the European level, there is not much yet developed. The European Commission launched earlier this year a public consultation to determine the legal employment status of couriers and improve their working conditions. The results should be available from November 21 on. We shall see what the outcome will be. If we look at national regulations, there is nothing to see in Germany yet. The new government has to deal with it, I'm sure. In the UK, we will find a minimum wage that applies also for workers, a hybrid between employees and self-employed persons. In Italy, freelancers are obliged to pay social contributions. They have to present their insurance certificate. And in Spain, there's also a compulsory payment of social security contributions from the platform. And Spain has created a 3rd category named trade, who have certain rights. In case of non-compliance, a contract for an indefinite period of time is presumed. The contract must have a specific duration and list the specific working time. Certain collective agreements are valid. There is the right to have 18 unpaid vacation days and public holidays. Rest periods, according to the European legislation, must be observed. And the termination by the employer can only be effectuated in case of a justified or a contractual agreed reason. In France, there is a special law for platform workers in the driving service and in the delivery industry. They have the right to go offline during shift. Driver can refuse to drive. There must be a certain distance and a certain minimum pay for the drivers, and they have the right to freely determine their shifts. What is new is, as of next year, union representation is available. The National Assembly in France just ratified a decree on platform workers, and that allows platform workers to hold union elections as of next year and to negotiate working conditions in general and the fees. We see the same development in Portugal. A bill was just approved by the government that aims to grant labor rights to drivers employed by digital platforms such as Uber or Glovo. And this includes formal contracts and social security contributions. Also in Belgium, we have social security as a compulsory element for anyone who works professionally and is not in a so-called authoritative relationship with an employer. So what do we see at the end of the day? Platform economy is not regulated or regulated very differently by the EU member states. A uniform EU regulation is somewhat in sight, but as said, implementation takes very long and does not encompass the core issue, in my view, due to the lack of competency in the social security matters. In my view, the group of solo entrepreneurs, gig workers, should be integrated into the social security system and enjoy certain minimum rights, maybe minimum wage, maybe financial support from the platform when paying into the social security system, maybe continued payment of wages in case of sickness. What I think is a bad solution is just to extend the definition of employee onto gig workers. I don't think that this will really help the workers. So far, my comments for today. Thank you for listening and see you soon again.